We shift our focus to our courts now. The High Court in Johannesburg has heard the challenge of the uMkhonto Sizwe Party against the SABC. The party has approached the court to stop the public broadcaster from referring to the 7th administration as the Government of National Unity. Now, in August last year, the matter was struck off the roll for a lack of urgency, but party leader Jacob Zuma wants the court to declare the SABC's use of the GNU unconstitutional. For more on this, we're joined in studio by SABC News senior reporter Canny Maphanga, just to give us a summation of today. Good afternoon, Canny. Let's start with this matter, or at least the genesis of the matter. It's an application brought by the MK Party as well as its leader Jacob Zuma. What is at the heart of the matter before we get to the arguments that were heard in court today?
Indeed. Well, this follows the watershed elections that South Africa experienced, the 2024 national and provincial elections, which forced the government of the day to be formed by a number of political parties, because no political party in South Africa came out with an outright majority in those polls. What that became known as, alternative to the 7th administration, as the Government of National Unity. Now, the SABC has reflected that this is the term upon which is used to describe this particular government of the day, but it's not the only term that has been used to describe that government of the day. There's been much political debate about whether this government that we see in the 7th administration is even a GNU, or Government of National Unity, and that debate, ironically, has also been platformed on the SABC. We've seen multiple views surrounding what our government looks like, what our government should be called. Now, the MK Party has taken issue with the, I guess they term it as the parroting of the GNU. They state, or argue rather, that the SABC is held to a higher standard because it's a public broadcaster that not only feeds millions of listeners and viewers with information, but has a mandate to educate the public as well. It is against that backdrop that they argue that it's not just simply a private citizen or a private entity, but has constitutional obligations and duties towards the citizens that they serve or provide information to. And because of that standard that is set, they're stating that the SABC has a duty or obligation not to just parrot or mimic what the government has termed itself as, but to qualify it in order to educate the public about the current political events of the day.
It seems they hold the view that it remains a grand coalition between the African National Congress and the DA. Was something to that effect stated today in court?
I think the argument is that the definitional elements of the GNU is more of a political debate. We understand it as an ideology. Some may argue that it is not a GNU, or it is rather a grand coalition, but that's part of the political debate. SABC is saying that we are taking ourselves out of taking a political stance on what this debate is, and we are reflecting the multiple views on what the political events of the day is, and that, according to the SABC, is the mandate and the constitutional obligation to inform the public about the changing political landscape in South Africa. But by doing what the MK would want the court to agree to, for example, they're stating that it's taking a political side if you use GNU and you reject the other political rhetorics that exist. Well, for example, if the SABC were to change its reporting to a so-called GNU, in that same breath, that's also taking a political stance, because you're also, in that same breath, on the other side, rejecting that political rhetoric or that political debate and ideology. So the SABC says the information is provided and it's given to the public, and we allow the public to inform their own views and opinions about the changing political landscape. And
they seek a declaratory order to this effect?
Yes, in terms of Section 172 of the Constitution. But with that declaratory relief, you actually have to spell out the rights that, or the constitutional rights that is being infringed upon, because it doesn't really give the court discretion. Once you've realized that right, the court will then have to give out that declarator. But there was a bit of a struggle with understanding what that particular right is. And the SABC, in its opposition, says that this case is, I guess, presented as a constitutional challenge, but it bypasses the relevant legislation that would inform the SABC's editorial policy, such as the Broadcasting Act, the SABC Charter. Of course, the MK says that they have exemptions that they've put forward to the court to state that this is why we've gone straight to the constitutional challenge. But the SABC's argument is that it doesn't get out of the starting blocks, because the internal remedies are there in the relevant legislation to deal with the concerns that the MK Party might have. But to jump straight to the Constitution may provide some challenges, because you actually have to realize that right, show how that right is being infringed upon before you can even seek that kind of a declaration in terms of Section 172 of constitutional invalidity, because that's quite a serious claim to make, or a claim to get from a court, which also in some cases has to be confirmed by the apex court. And effectively, if they were successful in getting that kind of relief, then it would mean that the SABC would not be allowed to use that term. And another example that was used is that because it's a political debate and ideology, for example, if you were to allow this kind of relief to go through, for example, someone might come and argue and say that the ANC, perhaps for an example, can't use the term national anymore because maybe people view the party differently after not getting an outright majority. It will bring up debates like that about how political parties or ideologies are presented to the public. Now, just because the SABC reflects that this is what the climate is saying about different aspects of it, doesn't mean that the SABC is taking a side. It's just reflecting the political events of the day and allowing the public to choose for themselves what that status may be.
It's honestly an interesting case that's unfolding there. But then I want to take you back to what Advocate Termutao said around the internal remedies. What did he say would possibly should have been the internal remedies before heading straight to almost dissect the constitutional matters? Well,
you may remember that when the matter first came about last year, there was a letter of demand addressed to the SABC asking the SABC to accede to this request of not using that political term. Now, that was seen as an interference in the editorial aspects of the SABC, and of course the SABC did not accede to that request. But in that letter, where they responded back to the MK Party, they discussed the multiple internal remedies that are available to address them. So there are not only different legislations that you can look at to try and identify to see where there is a possible breach by the SABC, but there's of course the BCCSA that you could have turned to as well prior to turning to a court of law, because essentially what is happening here is really it's political discourse, and you're asking a court to enter into that arena and intervene in the SABC's reporting of the continuous unfolding political developments in the country. So that's the point he was raising about you bypass these internal remedies that exist and are there. That's what the legislation is there to do, to run past that and create an quote-unquote attractive political debate and center it on the Constitution when the relevant legislation is there to deal with those concerns.
All right, Canny, thank you very much for that reportage. That's SABC News senior reporter Canny Maphanga just giving us a summation of proceedings from court today.